I'm a senior associate with Tully Rinckey. I've been practicing in this field around 4 years now, and throughout that time frame, I have handled national security cases from the completion of the SF-86 through potential derogatory issues, receiving a statement of reasons, going all the way through to a hearing and the appeal phases. So I've handled every facet of a security clearance case with multiple agencies, as you see they're listed on the screen. So today I come to you to talk about completing the SF-86. If you're not familiar, the SF-86 is the security clearance eligibility application. Primarily now, most agencies are having individuals complete that form online in the eApp system. The SF-86 is for secret and top secret level clearances. There is a lower level version called the SF-85P, which is used for public trust. So several of the topics that you'll hear me discuss today will cover both the SF-85P and the SF-86. The main difference is the SF-86 goes into more detail, covers a larger span of time, and has more in-depth questions on certain topics than the SF-85P. And if we could move on to the next screen there. Thank you. And just as a small disclaimer today, this presentation is for educational purposes. It is not intended to be legal advice. The views expressed in this publication are my own and do not imply endorsement by the Office of the Director of National Intelligence, the intelligence community, or any other U.S. government agency. If we can move on to our next slide, we're going to start with the importance of accurate reporting. Primarily what I see with mistakes made and even omissions on the SF-86 end up in a Guideline E statement of reasons being issued. And Guideline E is one of the 13 guidelines under the security directive to which they can deny a clearance. I like to refer to it as a catch-all or an umbrella, because you will find that not only do they address conduct-related issues, past workplace incidents, traffic violations, minor misdemeanors, things like that as matters of personal conduct, but mostly they express issues of lack of candor or dishonesty. And even if a minor mistake is made on the SF-86 and it's later uncovered in the investigative interview or during the background investigation in general, they will likely address it as a lack of candor issue, even though it may likely be explained as a common mistake. So it's very important that you read each question on the SF-86 very carefully, understand what the question is asking, and then provide an accurate, detailed response. So when I say read the question carefully, you'll notice that throughout the SF-86, some questions specify in the last 10 years related to your employment, in the last 7 years, and then there are several questions that are have you ever. And if you're rushing through and completing this form quickly and not carefully reading, it is easy to overlook whether or not the question is asking for a specific time frame. But that's important to ensure that everything is included. And then also things that are outside of that time frame may not need to be reported. And so that can assist you on occasion in some of the sections that we'll talk about today. So as I already discussed, minor mistakes can result in a few different types of actions. Initially, a lot of agencies will issue a letter of interrogatory if they find information through the background investigation or through the interview, and that letter will say, you know, we uncovered this information about you. We would like to have additional questions answered, and they'll give you a list of questions. With that document, it's not necessarily a derogatory action the agency's taking. They're just looking to complete their investigation. Another avenue that they've taken in the past is to go ahead and issue a notice of intent to deny. And they do that because, going back to my conversation on Guideline E, they see that any discrepancy between what you put on the form, what they may have uncovered in the investigation, and what the background investigation results, or what the interview results in, there may be discrepancies. And those discrepancies they find issue with, and they'll address it through an intention to deny the clearance. Now with that, and I'm sure will be covered in future webinars, there is a process that if you receive a notice of intent to deny, you will have a written response period and potentially a hearing before they just completely deny the clearance altogether. And so there is a process. It's not an immediate thing, but getting ahead of it early on when you're completing the SF-86 can assist you in preventing receiving the letter of interrogatory or a notice of intent to deny. So now let's talk about a few areas of the SF-86 which I've seen very common mistakes be made. Going in order of some of the difficult categories that may cause confusion and common mistakes is your foreign activities, contact, and travel sections. Those are sections 19, 20A, B, and C. It's very important that you read each of those questions fully and carefully and provide a complete response, as with any section on the SF-86. You'll notice that the form itself asks for close and continuous foreign contacts to be reported, whether they be your foreign contact or your spouse's foreign contact. It's important there to note that the agency doesn't really define what close and continuous contact is. My policy is anyone that you have either oral communication with, written communication with, online communication with, that is seemingly regular, whether it be every holiday, every month, every couple weeks, every day. It's important to report those individuals. Anything that's public, they search when they do their background investigation. So they can see your social media, they can understand contacts that you may have. So it's important to go ahead and report them. Now, if you do have a foreign spouse who has family members overseas that you've never had any contact with, you've never met them, you don't speak to them on a regular basis, then that is something that may not need to be reported. So it's very important to think about who you consistently keep in contact with and how often. Now, on the form, you'll note that it asks who that individual is, what relationship you have to them, whether they be a friend, colleague, what have you. It also will ask how often your communication is and the nature of that communication. What the agency is really seemingly getting at is, how often is this person speaking to a foreign individual? What are their communications? Is it, a holiday, happy birthday? Is it casual, how are you doing? Schoolwork, things like that. Or, their big concern is that, national security information is being kept safe and secure, and that those conversations, do not engage in, business conversations, anything related to your security clearance or your employment with a secured agency. So giving information in that in as much detail as possible is recommended to show, that you may have a foreign connection, but that it's not significant enough to be of concern to the government. Another section in this is foreign travel. And a lot of times that's somewhat overlooked because they are concerned, even if it's for tourism or if you are overseas for military or another business purpose, it's important to explain in detail when you left, how long you visited the country, and what the purpose of that visit was. It's common to travel, so it's not a deal breaker in having a clearance if you have significant foreign travel, but it is important to accurately report and accurately describe what those travel details involved. Lastly, in this section is foreign assets. And so that could look like a foreign bank account. It could look like a family property that you're set to inherit. It could be real estate that you already own and have ownership in. It could also be a foreign business entity that you're involved in. It's very important to provide those details in all accuracy. And honestly, the less that you do have, it's really important for national security purposes that you have strong ties to the United States and significant assets in the United States. So sometimes significant assets overseas can be more looked at negatively, but that is something that, again, getting ahead of it, reporting it accurately, and then discussing it with the investigator can be very helpful in moving forward and getting the clearance granted. So that's what I have on the foreign contact activities and travel section for most common mistakes and errors that I see. Let's move on now to section 21, which is your psychological and emotional health. Throughout that section, you will see different diagnoses that are asked about and whether or not you've ever received a diagnosis. It's always best to be as honest and forthcoming with that information. I say that because several agencies that have cleared individuals at some point may ask you to undergo a psychological evaluation, whether it be the Department of Defense, more specifically with Department of Energy. And so if you have had a diagnosis in the past and they ask for your medical records, and in order to get the job that you're applying for, you provide those medical records, you want to have everything reported that the agency may find in those medical records. And we'll get to drug use in a brief moment, but specifically drug use. I see most common when medical records are requested or individuals are requested to undergo a psychological evaluation, they will often admit to the psychologist or other medical professional that they had used past illegal substances or have significant alcohol use. And you want to make sure that everything coincides with information that they could uncover in the new psych evaluation or any of your past medical records, because that could again lead to a guideline E if it's not reported, and then you go through the process, you undergo the psych eval, and they find information. Now, having one of the mentioned psychological conditions on the SF-86 is not an automatic disqualifier. The government is concerned with understanding the condition that exists and having knowledge and certainty that the condition is under control and being well treated as the individual's being diagnosed and treated by their professional. So don't let having a diagnosis that's covered on the SF-86 be a deterrent. What's important is, again, providing information as to the diagnosis itself, the treatment that you're receiving, your intent to continue on that treatment, and if you have a prognosis from a medical professional, providing that information to give them a clear picture of what the issue is and reassurance that there is not a concern regarding that topic. An example I give with medical information is I had a case one time where an individual had not properly reported by mistake on a pre-employment application right before they got the SF-86, and it was just some small check boxes even, but yet they did acknowledge that there was a VA disability rating, and so the agency requested the VA disability rating, and so it was uncovered that there was a diagnosis there. So even making a small mistake in failing to report it, even though they did acknowledge that they had a VA disability rating, it just led to more steps to have to go through to explain what happened with the reporting and then where they were with the diagnosis and treatment. So again, and I'll repeat this probably several times throughout our presentation, getting ahead of it, reporting it in advance up front before they find out or review something in the medical record or psychological evaluation or other record that they find is always more helpful than allowing the government to find it and coming to you later with the information for you to address at that point. So next we'll move on to section 22, which is police record. Now your police record is where I see a lot of common mistakes, and the common mistake is the real understanding of an arrest, a charge, and a conviction, and what the SF-86 is asking. So the SF-86 has a section that I believe it states in the last 7 years, have you had a court citation, summons, arrest, or other action involving a criminal proceeding. So even if you're arrested and the charge, you go downtown, stay overnight, go to court, and it's never a charge, or they charge you and then they dismiss it, it still has to be reported on the SF-86. And it's very important to have a real understanding in what happened in that case. So, and this goes for those cases that have been expunged as well. So if it falls under, an arrest, a charge, or a conviction, it needs to be reported, and then the details, and as much detail as you have at the time, should be provided. So, if you were arrested and then it was later dismissed because you went through a pretrial diversion program, for example. Those type of programs, and I won't get too far into the weeds here, but essentially it allows you to complete, certain requirements, whether it be community service, classes, what have you, and then that charge may be dismissed or reduced or something along those lines. That's great. It's a helpful thing. for someone who's been in that position, but it still needs to be reported and properly explained as to the outcome of the case. You want to make sure that in your descriptions, there's a bit of, yes, this happened, here's what happened. And then also, it's also helpful to give them a little bit about how long it's been and why it may not recur again in the future. Excuse me there. So, with that being said, it all goes back to accurate reporting, really going through your records and making sure that you don't miss something, even by accident, when you're filling out this form. Because if they find it and then address it with you, it becomes a much more serious situation than just having a past criminal incident on your record altogether. You never want it to appear that you're hiding information or concealing information from the government, hoping that they may not find out about it. And a lot of times that's not the case. A lot of times it's just a mistake, but you want to make sure that that is known and that those mistakes are very limited to none when you're completing this form. So I'll move on now to section 23, which is our illegal drug use section. This section is another very confusing, very common mistake made section that I see. With that being said, the primary mistake revolves around THC and its legality and how the government feels and views its illegality. Excuse me. So with that being said, many states have legalized both medicinal and recreational use of THC and CBD products. However, the federal government has not. The federal government technically has approved through the Farm Bill, I believe it's the Farm Bill in 2018, basically a very low level of THC. However, I've had several cases that the individuals were specifically taking, a lower level of that CBD, reported it, and still had an issue with their clearance. But the big thing is to make sure it's reported. Even if it's, something where you have went to a medical provider, obtained a medical marijuana card through your state's legal prescription procedures, and your use was based on that medicinal use, it is still considered an illegal substance by the federal government, and it can pose a problem with obtaining a security clearance. It's tough to say because there's no bright line rule with the federal government as to the recency or the type of use or whatnot as to what will qualify you to be granted a security clearance. But with that being said, reporting it, being honest and upfront about your use, whether it be for medicinal purposes or whether it be for recreational purposes, it's better to get ahead of it than allowing it to come out when they interview you or one of the references that you've put on your SF-86 who have known you for a period of time. I had that come up recently. Someone's reference they had put in the section where it asks to list people that have known you for a specific number of years. They had actually answered in the affirmative that an individual had used THC, and that became a problem because it wasn't reported, and that individual ended up needing to address that issue. So I always say if it is something that occurred, and regardless of how recent it occurred, it's better to get ahead of it and report it and provide explanation as to your intent to discontinue using it and why you intend on doing so, and any other supporting statements for that is all important to include in that section to, one, be open and honest, but also provide the government reassurance that you acknowledge that it is illegal federally and that your intent is to discontinue using it. So let's move on to our section 26. This is our financial record. Financial record is really important. I see a lot of mistakes because sometimes individuals are not, maybe they don't keep up with their credit score. They haven't applied for something requiring credit in some time. It does occur that sometimes things happen from a fraudulent standpoint. Sometimes accounts go into collections from a medical account that you may have had from years ago and you not realize that it has gone into collections. It's not required, but my advice is always, if you're not familiar with your credit score and your financial picture, there are several free credit report websites and access to that out there. It never hurts to just take a quick look at a free credit report just to make sure that there's no surprise. There's not an outstanding medical account. There is not an outstanding, credit check or other credit card or other financial account that's been opened in your name. I've seen many a times identity theft where someone's identity is stolen. They open up a credit card and use it and then don't pay it, of course, and it goes into collections. And if you're not really up on your financial picture, then you may not be aware of that. Same thing with a medical account. If it occurred years ago, they may be sending a late notice or another delinquency notice to an old address. So it never hurts to just take a look at your financial picture before you fill out that section, just to make sure that everything is accurate and that you know what your financial picture looks like. With that being said, they don't necessarily go into, your financial record or ask for your bank accounts or your bank account balances or anything like that. Their concern is whether or not there is debt that's outstanding, that's not being handled, not being paid off, or in some way taken care of. That's the same to go with tax filings. So in the tax filing section, you'll notice that it asks for whether or not there's been any late tax filings or late tax payments, both federal and state. And so, if you have requested an extension and that extension's been approved, then you would not, that's not a late filing. If you owe taxes, but you're not delinquent, you're set up on a payment plan and that payment plan's current, that's not delinquent. So be careful when you're answering those questions. And my advice is if you do need, assistance, reach out for that assistance before it's too late. It's better to get help and to ask questions regarding the SF-86 before it gets to the point where there's mistakes made and information is discovered, and then you're having to respond to it from a negative standpoint. One thing I didn't mention in my PowerPoint here that I just wanted to touch on really quickly is section 13A and B, which is your employment history. It's very important to, again, take a look back at past resumes, past documentation, and really ensure that every employer that falls within the time frame is listed to include an accurate depiction of why you left that employment. They will reach out to your employers, they will interview them. It is important to be as honest as possible there with each situation. If there was a termination or you left on mutual terms, you want to be as honest as possible because, again, they reach out to those individuals, and it's better to provide your side and your details in the most accurate fashion before they contact the employers themselves. So I know we're running close with about 6 minutes left, so I want to go ahead and open up the floor for questions on what we've talked about today.
If there are any questions that anybody has, please submit that via the chat, and I'll send them over to our presenter.
Okay, someone did ask how to report a termination under investigation. And so I want to, if you left while the investigation was ongoing, that's a bit difficult. But in the explanation box, the best way to handle any termination is to give as much detail, whether it be what happened. I mean, I have a lot of individuals that, they ended up having EEO complaints, OSC complaints, and they feel that the termination was retaliatory. I would include those details. If it was something related to performance or even conduct, I think it is wiser to admit to, I was let go because I had a poor performance score or I had misconduct in my record. It's better to get ahead of that and to address it before they contact that employer and they say, oh, they weren't performing or they were not behaving or they were late or they were AWOL or something along those lines. I think it would be the best case scenario to, again, define everything that happened, and then, you know, you can address your side of the story too if you had issues with that employer. So another question that came in is, if you're denied a clearance, how soon will you be able to apply to a new agency? So the favorite lawyer answer to that is it depends. If you are applying through Department of Defense for either an agency clearance or a contractor clearance, and it is fully denied, you would have to wait a year to reapply. It's 1 year from the final decision. Now, each agency is going to be that same way. So Department of Energy, it would be 1 year from their denial. FBI, CIA, other agencies would also be 1 year from their denial. Now, if you applied at the FBI, for example, and they deny you, you can technically apply for Department of Defense. On the SF-86, there is a question that requires you to report that you've had a previous denial of a clearance or a revocation of a clearance. So that can be a hindrance to obtaining a new clearance, but you can still apply before that 1 year period is up. So another question that's coming through is, the background information is from your credit report, but it's not accurate. What should you do? So, and with that, if your background is not accurate, I would, pull your accurate credit report, excuse me, and I would, review what is wrong, and I would file a dispute with those credit agencies, and then I would definitely address that on the SF-86 and with the investigator, that you've done your due diligence to review and find inaccuracies in your credit report, your credit documents, and the actions that you're taking to resolve it. Another question coming through is, what's the longest time you've seen between submission of an SF-86 and adjudication? That question depends on the agency and the level of clearance itself. So public trust, there's really no exact ranges of time from submission to full adjudication. Public trust, of course, being the lowest level, would be adjudicated the quickest. Secret and then top secret. Different agencies, can definitely take much longer. Some agencies require polygraph exams for the higher level of clearances. So I think the longest, I've seen them take upwards of 2 years with certain agencies, but typically most agencies are not that long. I would say most agencies would max out around 12 months. So last question it looks like we may have time for here is, would it be advisable to hire a lawyer like yourself to assist with the SF-86 process? In my opinion, absolutely. Something that experienced lawyers in this field have is some of the mitigation techniques that the government really looks for when they're reviewing a security clearance application. So it's not all about, the facts and what happened in certain situations, specific to crime or past drug use, but it's the ability to reassure the government that these past actions are not going to recur in the future once you've been granted a clearance, and really showing the government that they can trust you as an individual with high-level classified material. And I think that's all we have for our questions here today. Thank you all for coming and participating. It's been a pleasure to prepare this and share with each of you. And if you have any additional questions, please reach out to our firm. One of our security clearance attorneys would love to assist you.